Welcome back. The focus in the trial, within a trial probing the killing of soccer star Senzo Meyiwa, has now shifted to the pointings out of the crime scene by accused number one, Muzi Sibiya. The defense contends that Sibiya was tortured on several occasions and forced to participate. Lieutenant Colonel Nkosikhona Hadebe is currently on the stand and also disputes that Sibiya was assaulted. An interpreter who was also present during an accused number two's alleged confession testified he was willing to make the admission.
Magistrate Vivian Cronier, who concluded her cross-examination, was grilled on why she had failed to act on the day Ntanzi was brought to her for the alleged confession, as he had already been detained for 8 days without appearing in court.
Why did you proceed with someone who had indicated to you that he was in an unlawful detention from the 16th of June? Why did you proceed in taking down the statement from a person who had been kept in an unlawful detention?
Hy was verdedig op daai stadium. Hy was begeerig om die verklaring te maak op daai stadium.
He was represented at that stage. He wanted to. It was from him. He's the one who showed that desire to speak or to say something at the time.
Cronier also admitted that the manner in which law enforcement brought Ntanzi to her was unusual.
This was the first incident that you witnessed or that you came across with from your experience, to see an accused person being brought by heavily armed police officials.
Dis correct.
That is correct.
A court interpreter who was present when Ntanzi made the alleged submission testified that by her observation, Ntanzi never made the confession under any duress.
My lord, my overall impression was that, of course, looking at the demeanor of the suspect at the time, he appeared to me like somebody who really wanted to speak.
Nor had she witnessed any injuries on him.
And do you remember if the suspect had any injuries?
Not at all, sir.
Then the focus turned to the alleged pointings out of the crime scene by accused number one, Muzi Sibiya, which his lawyers are challenging and say was conducted after he was tortured.
The nature of the assault was choked with a plastic bag in his face. Will you comment on that?
My lord, I don't have any comment on that, but I believe that he would have reported that too.
Cross-examination continues.
All right, well, the defense contends that Sibiya was tortured on several occasions and forced to participate. Lieutenant Colonel Nkosikhona Hadebe is currently on the stand and also disputes that Sibiya was assaulted. An interpreter who was also present during accused number two's alleged confession testified he was willing to make the admission. Legal analyst Mpumelelo Zikalala joins us for analysis on the latest on the Senzo Meyiwa murder trial. A very good evening to you, sir. Always a pleasure to see you. Thank you for joining us as always.
Good evening to you, and also good evening to your listeners.
All right, you know where I want to start, Mr. Zikalala. I think what is important is for us to talk about what should ideally happen from the moment that an accused is arrested to his or her first appearance. I mean, we're also hearing that there was 8 days before the accused even got the chance to appear. For the sake of our viewers, Mr. Zikalala, if you can just paint for us a picture of what exactly is supposed to happen, the exact protocol from the time that the accused is in fact arrested.
It all stems from Section 35 of our Constitution, which then affords the accused certain rights. Firstly, you have a right to be brought to court within 48 hours, meaning that as soon as possible or reasonably possible, must appear in front of a magistrate who is then going to explain your rights to you in terms of legal representation. It's very important, by the way. After that has been done, a full explanation as to why you've been arrested must then be afforded to you. You must then be told about the instances of bail in which you can then apply for, or if it needs be, you are released on warning. So if all those things, which especially coming to highlight the importance of your right in terms of keeping silent, access to legal representation, and all the other factors that are listed in Section 35, then you have a problem with regards to that particular detention. In fact, our courts are very particular with appearing within the 48 hours to such an extent that if anyone would appear in any presiding officer, whether district or regional level, If it is clear that the amount of time that you've spent in jail is way too much or above or it's over the 48 hours, then the presiding officer has an obligation to release you because your rights have been broken in this instance. Then the question would be, who can you run to protect your rights if you can go to a magistrate and be able to explain that? Now, as part of housekeeping matters and ensuring that all the legal rights and legal framework have been observed, those are the exact type of questions that you should be asking as the presiding officer dealing with this type of matter.
All right, so we are now no longer sure at this point, if the accused, and you raised this point very importantly, if the accused was even adequately or properly represented. And as you say, this is a huge problem then for the courts and it might in fact be a huge problem for the case itself. What are the possible implications or repercussions should it come out that in fact this, how the defense is painting the picture is in fact how it happened? Let's leave aside the issue of the torture, but the issue of representation, and even bigger so, the fact that 8 days without, appearing. These issues are a problem. What are the repercussions there?
The arrest in itself may be placed into question, which will also place into jeopardy the whole trial in terms of the person being found innocent. If there's no fair trial that has taken place, then the court can come back and say, in fact, we must let you go because your rights have been infringed in this particular manner. Secondly, it's not so much the rights that I explained to you, it's the understanding of what rights are then afforded to you, the consequences of you admitting to any of the things in which you're going to admit to, and the perfect way in which you can be able to render out to do that is to have legal representation right next to your side. A person will be able to explain what can and can't be done, what are the implications of doing such. Because if you don't have that in front of you, and it's simply just explain to you that you have a right to remain silent, without the consequence of why the right to remain silent is there in the first place, it means that you're going to agree or deny things that you don't know the consequences or what the consequences are actually going to be. Hence why legal representation is so important. Hence why the Criminal Procedure Act also acknowledged that there are going to be instances in which confessions are going to be made. Let's make provisions as to exactly when those provisions or when those confessions are going to take place. But let's place a magistrate, someone who's impartial, someone who the only thing in which they are looking for is compliance with the law, someone who's going to ask all those important questions just to make sure that the confession is obtained in an authentic manner. Yeah. Now, the results being, if any of those rules are broken, then that part or that section of the evidence can't be considered by the court. Is going to be taken if the confession was never made in the first place.
Yeah. What was rather interesting as well today was the issue of language, which was raised quite a lot. And I saw there was quite a bit of discourse by LLB Twitter, which I'm assuming you're part of today, with regards to the issue of language in courts. And many were talking about, the impracticality of it all in a country like ours. We have so many languages. But I want to talk about this issue of language that was raised. Is it a usual occurrence that the issue of language is raised by for instance the defense? I'd imagine that there've been quite a few issues over the years when it comes to either the defense being misinterpreted or not understanding or some of those issues. But is this a usual occurrence?
Definitely it is. There are many times in which either, let's take from lack of interpretation. So the matter would not proceed because interpretation is not there. It's crucial, by the way. Why is it so?
Yeah.
It is not for the legal practitioner to understand the proceedings, for the person who's the accused to understand the proceedings which are taking place, but most importantly, understand the consequences. So it's not the process of being arrested and being sentenced. It's knowing what am I being arrested for, what am I being sentenced for? What are the factors which are looked at by the court? That's the only time in which I'll then be able to see that indeed justice was being served by me being arrested. So that's where the question of language then becomes important, because if you do not know and you're not able to follow the proceedings as they are going along, how are we going to give instructions to a legal rep in terms of what to say, what not to say? In instances where there are going to be things which are going to start coming up that we'll start to remember as we go along, where will you get the opportunity of thinking, this is what they're looking for now, and I must then tell my legal practitioner as to how this matter ought to be. Now, the dynamics when it comes to South Africa is that we have many languages that are there, and some of them which are so intricate. For example, if you interpret something in Zulu, there are many other interpretations that may be there. So it's important to get someone who's going to fully understand the Zulu language or any language which is being interpreted, be able to interpret it in a manner within the context in which it is stated, so that those proper instructions are going to be received. The manner in which you want to make those submissions to court is also going to be clear for everyone to understand.
Yeah. Is that a valid defense that in fact can be used? You know, can accused simply say, listen, I don't actually know what I was saying. I don't know what I was confessing to. I don't even know what I was asked. And this is my defense. Basically, is that a valid excuse, a defense that one can then use in court?
It may be depending on the circumstances of the facts of the case. Now, in this case, you are simply dealing with a confession. Saying that I did not understand what the confession was about, for me, it's enough proof to say that this person did not understand what they were agreeing to. Most importantly, they did not have proper or informed consent or knowledge as to what the consequences are going to be when they admit in these particular instances. So it's much better that we remove it or place it away and allow the matter to continue as if the confession was not there. And which, by the way, as a side note, the state's case should be strong enough to say, we are going to succeed whether there's a confession or not. Usually confessions are used in which maybe one of the witnesses or one of the accused is not there. They've died or they're no longer available. So the only piece of information that we have is this confession. Hence why it is important for it to be utilized. Where the accused is there, as the presiding, as the investigative officers, you've done your investigation in a perfect and well manner. There's not even a need for a confession to come up, because the manner in which you've done a thorough job in doing this investigation, you don't even need one if it was done in a proper manner.
All right, Mr. Zikalala, always a pleasure hearing your legal analysis. That is Mpumelelo Zikalala, who is legal analyst and attorney.